Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. In case anyone else has noticed, I'm the one that opened up the shades today. It's been dark in here. I'll probably hear about it on the camera stuff. So we are set this afternoon for 2 oral arguments. The first case is Wilson versus Shenandoah Medical Center, and it looks like the parties are ready. And Ms. Penner, you may begin.
Thank you, Your Honor. May it please the court and counsel. Plaintiff missed their 668-11 deadline by 3 months in this case. The trial court excused that untimeliness and ruled that the expert would be allowed to testify at trial. So why are we here? We're here because we believe the trial court abused her discretion in that ruling, and also to ask for some further guidance on 668-11 and the good cause analysis. In particular, a couple of
The other curtain, too, if you want to. I was just making a comment. It was really nice to have sunshine, and then the sunshine killers come in. And we did pause the clock for you. Moment.
Iowa case law, including this court's opinion last Friday in Curlin, gives us the framework for the good cause analysis under 668-11, and whether a party who is untimely in their designation is allowed to use that expert. So I'd like to just march through those factors that the court has identified for us. First of all, plaintiffs in this case didn't articulate any cause. They never provided an explanation why they missed the deadline. We think that's a threshold issue that the courts should consider. Second, there was no uncertainty in this case about the deadline. It was proposed by plaintiffs. It was agreed to. There was simply no judgment calls, no reasonable alternatives to what that deadline was. It was clear. Third, given the clarity of the deadline, you can go to the first Hansberger factor, which is whether it was a serious deviation. 3 months under our case law is a serious deviation from the deadline, and plaintiffs were 3 months late. And that brings us to the fourth factor to discuss, and that is the defendant's conduct. Okay, and this is where the trial court centered and identified kind of 3 categories of what the defense did wrong that led to the plaintiffs missing their deadline. One was mere silence. One was to continue to work on the case. And the third was a purported delay in deposition scheduling. First of all, mere silence by the defendant, we would respectfully submit, should not support a good cause ruling on the other side's missing the deadline. Defendants, one party does not have an obligation to remind the other party of their deadlines, either way, okay? Or to tell the other party, we're going to file a motion soon, telling them to cure, okay? There's just not that obligation, and it makes a party the brother's keeper, which the Hansberger court rejected. Second, the court was critical of the defense for continuing to work on the case. Okay, so there was a reference to deposition scheduling discussions before the expert deadline passed and after. Before the expert deadline passed could not support good cause. they haven't missed the deadline yet. Of course they're working on the case. Of course they're discussing scheduling. After the deadline passed, one might ask, so why are you still working on the case, defendants? So first of all, the first discussion about this deposition scheduling after the deadline passed was in the same month. So the deadline was September 1. There was discussion by email in September about scheduling depositions. But in September, it was not even a month late. If the plaintiffs had designated in the month of September, the defense may not have ever challenged that. We look at this court's opinions and the opinions of the Court of Appeals about what you view as what's a serious and significant delay. And I believe it's about 2 months or 66 days is what the case law has said that's serious.
The discussion in September about scheduling depositions, was that about scheduling expert depositions or other people?
These are fact witnesses only, and the parties, plaintiffs.
You're talking about defendants, the conduct of defendants' conduct, but could you address prejudice or the lack thereof? Because the expert ultimately designated 3 months late was the same one who did the certificate of merit and the same one in the interrogatory answer, the registered nurse Bierman.
The court identified, the district court, kind of two ways there was not prejudice. One, the remote trial date, and second, the discovery answer and the certificate of merit. I'll talk about the second first, since you brought the certificate of merit is a substantively different thing than a 668.11 designation. 668.11 is about who's going to testify at trial. Certificate of merit is not. 668, one of the objectives is to give the other side certainty about the experts who are going to testify at trial. Certificate of merit is essentially irrelevant on that point because they don't have to use the same expert, and sometimes they don't.
What about the interrogatory answer, though?
Answer did nothing more than regurgitate the certificate of merit.
It's the person who's testifying at trial, not just that's who we're relying on to say the lawsuit has merit.
It's not a certification, and it's easier to amend and modify and supplement interrogatory answers than to change 668.11 designations. Once a 668.11 time has passed in the designation, they need leave of court to change experts, to add experts. Not the same with an interrogatory answer.
I read the district court's decision largely as focusing on prejudice. What prejudice was there to your client with this delay?
Lack of certainty about who these experts are. The defense prepared their experts and their reports and designated timely and did so without the benefit of knowing what the opinions were. The certificate of merit and the interrogatory answers just say the nurses breached the standard of care. That's it. That doesn't say how. No grounds, basis, or reasons for that breach of the standard of care. So the defense, if you read the nurse's defense opinion, was in the summary judgment record, it responds to the petition. When defendants do expert reports, we respond to the plaintiff's experts. But in this case, they had to do what they could, responded to the petition. What that usually means is if the expert is allowed to testify and is not barred, is we have to redo expert opinions. And it adds time, cost, et cetera. So you do lose. It's real. The strategic disadvantage that is lost, that's talked about in the Stanton case, it's real. It really is to the practitioners doing these cases.
Prejudice, the cost and expense of redoing an expert report?
There is, and we cited all the cases we could find, on the inherent prejudice that comes when the party with the burden of proof doesn't go first, okay? And plaintiffs go first, defendants respond. And to say that, well, it's not prejudicial if it's reversed, that seems contrary to the rules of how litigation progresses, how trials progress. So there is inherent prejudice when the defense goes first.
The interrogatory answer and the certificate of merit referred to the nurse having, will speak to breach or standard of care, but did not mention causation, and only later in the untimely expert designation do they indicate there will be trial opinions on causation and damages.
I believe that the plaintiffs in that same interrogatory identified a lot of treating physicians. I suspect that might be where the causation piece of it will come. That is.
You have cases, kind of the universe of cases where the disclosure is 3 months or more late. What kind of facts or factors would support finding good cause in those circumstances?
Sometimes the kinds of good cause that seem to fit in the court's, the definition of good cause that the court has adopted for this are perhaps what the court found in Curlin. Legitimate misunderstanding of what the expert deadline really was. And it happens. And that's maybe a good example of when it happens. So there can be lack of clarity on what is the deadline.
Let me respond on that point. So one of the things that the Court of Appeals majority mentioned, and it bothered me a little bit too, is in March 2022, there's a request from your client for a trial date in July of 2024. And then one of the reasons for this July 2024 trial date is completing discovery, including expert designations and expert discovery, will require a substantial amount of time, which further supports a trial date, et cetera, outside the time standards. Well, if the expert, if the deadline was actually September 2022 for their expert disclosure, it seems that doesn't seem like that designation deadline doesn't seem like something that would justify a July 2024 trial date. Including expert designations and expert discovery.
Whether or not the person who drafted that had in mind when they said designations included the final reports, because the fact witness depositions do sometimes result in supplemental expert reports. When the defendant is a physician and the defendants are deposed, sometimes the plaintiffs have to supplement those expert reports, and there's subsequent supplementation by the defense, and it stretches out. It stretches out.
summer leading up to the deadline or after the deadline, did the defendants do anything to mislead the plaintiffs into thinking you would not be enforcing the deadline?
Think so. We certainly don't think so. And the conduct after the deadline ran, if the court will scrutinize, I know, there's only like 4 or 5 pages in the summary judgment record of the email exchanges. I don't think the record bears out any allegation that the defense resulted in any delay in addition to what the plaintiffs caused in failing to come back, asking for deposition dates. There was a 3-month gap between written discovery and requesting the deposition dates. There was a 5-week gap between communication and when they came back. So the defense conduct simply doesn't bear out as a good cause reason. And my time is up, and I will come back and hear about it.
Thank you.
Honorable Madam Chief Justice Christensen, Associate Justices, may it please this court. And Counsel, Ms. Penner, it was a pleasure to meet you here this afternoon. Good afternoon, Your Honors. It's my first time before this court, and it's a pleasure to be here. Thank you for the invitation. My name is Jessica Zupp. I have been a lawyer in Iowa since 2006, and I practice in Denison, Iowa with my twin sister, Jennifer, who happens to join me in the back of the courtroom today. I am also joined here this afternoon by my pretrial co-counsel, Attorney Andy Sibernson from Omaha, Nebraska, and Attorney Gary G. from Shenandoah, Iowa, who also joined me in the back of the courtroom here today. Collectively and on behalf of our clients, Doug and Jane Wilson, we request that this court interpret Iowa Code Section 668.11 to only require evidence of good cause for an extension, and not to require evidence of good cause for the delay precipitating the need for the extension. And we believe that this is a correct reading of the statute for 4 primary reasons. First, it honors the singular good cause language in the statute's plain text. Second, it reconciles that singular language in the statute's text with contrary and dual requirements in related Iowa Rules of Civil Procedure 1.977 and 1.302. And third, it implements stare decisis by applying and harmonizing this court's precedent in Donovan, Hansbarger, Nedved, and the unanimous opinion issued just this past Friday, authored by Justice Mansfield. And finally, it advances the constitutionally based, long-standing judicial preference for a trial on the merits. Because the district court in this case properly balanced the traditional good cause factors of seriousness, prejudice, and the defendant's contribution, because that balancing was not clearly untenable or clearly unreasonable, and because district courts are vested with wide discretion to make these kinds of pretrial judgment calls, even in close cases, we believe that this court should affirm the opinion of the Court of Appeals and ratify the district court's decision to grant the Wilsons a brief extension of the deadline in this case.
Was your designation filed under 66811 3 months late?
The record is not crystal clear on exactly the timing of the filing, Your Honor. When the plaintiffs resisted summary judgment, there was an affidavit sworn to by Attorney Sibernson in the back, and he indicates in his affidavit that when the lawyers were bantering back and forth about scheduling the discovery depositions, he mistakenly, but in good faith, believed that they were not strictly enforcing those deadlines. And there's not a statement in the affidavit that, hey, this is why I was late, but the inference is they were sitting and waiting for discovery to be completed. And I think it's important to note that the delay of the discovery in this case was not at plaintiff's request. This was the defendant's request to push back the discovery. we had asked for discovery depositions, I believe it's the Exhibit A in the summary judgment emails, back in May, and said, can we please depose some witnesses? And the defendants requested, first, let's complete written discovery. We said, okay. And then they said, well, we want to depose your plaintiffs first before we pony up the doctors and the nurses. Fine, we said, okay. And we agreed to that. And then between May and September, when the expert designation deadline ran, the defendants literally did nothing to perpetuate those depositions that they had requested the timing of. And
Defense counsel does not have an obligation or a duty to remind plaintiffs of expert designation deadlines? Okay. If we affirm the district court in this case and the Court of Appeals majority, what impact will that have on these deadlines?
have that much of an impact, Your Honor. I think the most significant fact in this case is the issue that I believe Justice Mansfield addressed in his questions to my opposing counsel, which was the answer to interrogatory number 16. That was Exhibit E in the summary judgment. And as Your Honor correctly pointed out, that discovery answer identified name, qualifications, and purpose. And the interrogatory also said, who are your testifying experts going to be? And when we look at 668, it says name, qualification, and purpose, who's going to testify.
Expanded after the interrogatory answer, which didn't say anything about causation, then the designation in December added causation and damages. Isn't that significant?
Materially significant in that the purpose for which she is going to testify was broadened. However, I would point out that the defendants didn't complain about that issue and it wasn't preserved for them by appeal. I would also point out that the defendants at summary judgment, if you will read, it's Mr. Geis was presenting argument to Judge Reyes in the lower court. What he indicated at that time, lost my train of thought on that, Your Honor. Can you restate your question for me so I don't?
You were saying that they didn't take issue with the expansion of opinions. Okay.
Your Honor, thank you for the clarification and the reminder. Mr. Geis told the district court judge that the evidence in the record was that one-to-one nursing care was ordered for Mr. Wilson, and he told the judge at that case that the nurse admitted that she stepped back a few feet, she turned her head, and then, no surprise, a guy on major anesthesia and sedatives, guess what? He fell down and hit his head. And so I would suspect that potentially that's a jury question, whether that one-to-one care was breached and whether a promise of one-to-one care actually would require a causation expert. But in any event, point well taken. Yes, Your Honor, the actual designation does go beyond the interrogatory answer. You are correct about that.
Here we have 3 months delay. What if there's 6 months delay and then a motion for summary judgment in the same situation? Where should we draw the line?
Well, as Your Honors pointed out in the majority opinion last week, I think when we're talking about seriousness, we don't look at seriousness only temporally. We should look at it in the context of the balance of the rest of the facts. And I think when we have a case here where we had the same lady in the certificate of merit, the same lady in the initial disclosures, the same lady in the discovery answers, and the same lady in the designation, I think that reduces the impact of a 6-month delay. And so I think that the court has to balance all of those factors, which thankfully our district court judges are well equipped to do.
And I'm sorry, remind me again, how many months were there until trial between the disclosure deadline and the scheduled trial date?
So our disclosure deadline was September 1st, 2022. The trial was scheduled for July 2024, so it was approximately 18 months away. I think in some of the underlying briefing in this matter, the plaintiffs had pointed out a case called Preferred Marketing Association versus Hawkeye. And it's not a 668 case, but it's a late expert case. And in that case, the parties had attempted to introduce a new expert a week before the trial date. And the judge always creative, said, okay, we're going to do some depositions on the weekend, you're going to get a little bit of free time with this expert, and we're just going to go forward. And when this court reviewed that, they said that that's not prejudicial, that the court had put in enough precautionary measures to fix any last-minute surprise that would occur. And so I would submit to this court that if a week is good enough to be fixing the prejudice in that case, a year and a half is certainly sufficient in this case.
The 811 case where the idea that the legislative goal was to accelerate a determination of do you have the expert testimony, who is it, well before trial, and that preferred marketing didn't involve a good cause escape hatch for a late expert.
About that, Your Honor, and the purposes of 668.11, which the late Chief Justice Jerry Larson had expressed in the Donovan opinion, is that we want to provide the certainty about the experts. Well, we did that here in the certificate of merit, the initial disclosures, and the interrogatory answer. The purpose also is to make sure that we don't have frivolous cases coming through the courts. Well, I think the certificate of merit statute by itself sort of dispenses with that concern all the time. And then we don't want to have doctors and nurses having to waste their time to deal with cases which might be frivolous. And so I think those purposes were satisfied in this case when we had the interrogatory answer to number 16, way back in June of 2022.
A legitimate issue as to what is the deadline, because it went up on appeal, and it was, and even the defendants acknowledged it was a, kind of an open question to be determined. But here you don't have. Help me out with the lack of an excuse for the 3 months delay.
I guess I would just point out, I'm going to go to the language of the statute first. 668.11 says that the court only has to have leave, good cause, to grant leave for the expert's testimony. It doesn't say good cause for the reason for delay. If you would compare that language to 1.302, which I mentioned in my introductory remarks, that is the rule that talks about how you have to serve your original notice within 90 days and what happens when you blow the 90-day deadline. And 1.302 sub 5 says that you have to establish that there has been good cause for the failure of service. I think that that is akin to good cause for the delay in designating, and that language is simply not present in 668.11. And so the fact that we have good cause for the failure in 1.302 and only good cause for extension in 668.11, I think is some legislative indication that 668.11 is forward-looking, not backward-looking.
Has the Court of Appeals or our court accepted that interpretation that limits the good cause requirement to just the request for an extension as opposed to an excuse for the delay? Or would this be the first?
The Court of Appeals, it's difficult to say because a lot of the Court of Appeals opinions, the flaw that they have in most of them is that they either didn't do discovery, they got compelled a whole bunch of times, defense counsel was emailing them a whole bunch saying, hey, who are your experts going to be? And so, question becomes then when the Court of Appeals is talking about, oh, hey, by the way, they didn't even have an excuse, was that a dispositive issue in the case or was that dicta? There are cases, however, particularly including the one authored by now Justice May when he was a judge on the Court of Appeals in the Stanton case. And there was some discussion about, what is the reason that you missed here? However, I call this the footnote 4 case. This is how I recall it, because in footnote 4, Judge May said, hey, this case is totally distinguishable from Hansbarger because Hansbarger, you had a whole bunch of discovery going on, and the expert's name was known and it was given, but in Stanton, they didn't have that problem. And so there are Court of Appeals cases talking about should we have good cause for delay. But there's not really any analysis in the cases that talk about that. What I think it harkens back to is back in the original case decided by Your Honor's father in the Donovan matter, what he did was he looked to 1.977, just the default set-aside rule, because that rule also talks about good cause. But it says good cause and inadvertence, surprise, excusable neglect, unavoidable casualty, and mistake. And this court has always interpreted that good cause language to mean meritorious claim or defense. And so I think what the courts have done over the course of years, which is fine, I think it's just been an innocent over-borrowing from the 1.977 rules that talk about how you need to have a good reason. I think it makes total sense in the 1.977 cases, because 1.977 has a whole list of reasons. But 668.11, on the other hand, does not.
In other words, it seems to me that if you don't show good cause, are you saying that you don't have to show a good cause in the sense of a good reason, as Donovan said? It just doesn't matter at all?
Yeah, Your Honor, I do think so. If you read the Hansbarger case, his reasons for why he missed the deadline was, one was just oversight. Well, I think a lot of missed deadlines happen because of oversight. But what the court did in Hansbarger was excused the oversight and said, look, this guy had done a whole bunch of discovery along the way. They had their experts in hand. They were prepared to go. And I think that's exactly what has happened in this case. Even if it was just an oversight, it was just a mistake, I think we still fit neatly under Hansbarger for that reason, Your Honor.
Kind of play this out a little bit. So under 668.11(1)(a), the district court can extend the disclosure deadline or designation deadline for good cause. And I assume at that point, the judge could say, well, trial is not for another 19, 20 months. We're going to go ahead and extend the deadline beforehand, before it passes, right? So your argument then is in 668.11 sub 2, the court could exercise that same reason. That would be good cause for allowing the testimony for a missed deadline. Is that kind of the gist of it?
Yeah, I think so, Your Honor. And I think, if the insinuation in the question is that we should be required to file a motion ahead of time or to ask for an extension ahead of time, if you look at 147-140, the Certificate of Merit statute, that statute actually says you have to file your motion ahead of time. Not only does it say you have to file your motion ahead of time, it actually also says if you don't have medical records all in yet, that's also good cause. And so I think we would fit that case too. We don't have all the discovery in yet because the defendants wouldn't line up the depositions. They were too busy. The final, I see that my time has expired. May I just wrap up? Sure. Okay. The final thing that I just want to point out, which I think is important in the record, is when the defendants finally filed their designation, the evening before it was due, they said, page 2, paragraph 6, discovery is ongoing. We reserve the right to designate additional experts. And I would submit to the court that if it's good for the goose, it's good for the gander. On its face, it establishes that they agree that there's good cause. And so to err is human, Your Honors, but to forgive is divine. And we ask that this court interpret 668.11 with an aura of divinity and forgiveness about it, honor the statute's plain text, reconcile it with the rules of civil procedure, apply this court's precedent, and give the Wilsons their day in court. Thank you.
It's not too surprising that the defendants would say such a thing in their designation, given plaintiffs had not designated yet. So good cause for delay versus good cause to allow testimony. I'm not sure I understood the difference. I think that 668.11(2) requires good cause to allow an untimely expert to testify. And this court we've got a lot of years of jurisprudence in both courts in Iowa on what that is. Seems like plaintiffs are asking to change the law. We're asking for a little clarification is all.
Assume there is a pre-deadline request to extend the deadline. What would be good cause to allow that?
I think that it is that's not a very good answer maybe, but it's very fact and case specific. Some of the things might overlap. I think that you might have,
District court judge, and somebody came to me and they had a motion to extend the deadline. And they said, Judge, the trial's not for 3 years. Let's kick the 66811 deadline until 6 months prior to trial. Okay. Is that permissible under the statute?
you could ask, and the defense would say 6 months before trial's too late to get the expert discovery done. And then the answer might be why, and possible things that are dialogued in those kind of things are personal circumstances of counsel, of the expert.
Discretion for a district court judge to grant such a motion as long as the deadline was 18 months prior to trial.
I would not endorse a black and white bright line rule. It could.
Use of discretion. Why can't that same reason be good cause to excuse the failure to timely?
Before trial, and because lack of prejudice is one of many factors. This court has said in the Nedved case, lack of prejudice wasn't enough. Okay, if that was the only Nedved case.
Really have discretion then under our case law? I mean, why isn't that a discretionary call for a district court judge to manage his or her docket and say, I think a deadline that's 18 months prior to trial is reasonable, the parties have plenty of time?
Case, if you're mixing entire case deadlines in the mix, does a district court have the discretion to manage their docket? Yes, but then there's just a lot of things that go into such a question. Some cases, there are 20 experts on each side, for example.
A situation where lots of factors are at play, that's exactly why we say it's within the district court's discretion. So why can't the judge look at his docket and say, nobody's going to be prejudiced by having a deadline 18 months prior to trial. It doesn't matter why they want it done. Why would that be an abuse of discretion?
Past 668 saying the designation of experts is 6 months after the answer.
It's a backdrop of our case processing deadlines, which have a certain trial schedule contemplated, which the parties, if I understand it right, correct me if I'm wrong, one party asked to continue the trial date over the objection of the other, right? So the landscape's changed. Why can't the judge make that decision?
I think there's at some point you have to go back to 668:11 and the objectives of the statute. It was to provide certainty of experts early in the case, to protect the healthcare provider from defending against cases that were not going to make it to trial because of the expert. So is there a limit to your suggestion? I think maybe when that's fully presented for that question, I think that you have to back up and look at the objectives of 668:11. And I'll end the prejudice caused by a remote trial date, we don't believe should have a very strong role or given much weight. In a case like this, 66811 sets deadlines early to get, and if a defendant moves in to strike an expert and for motion for summary judgment promptly after that deadline is missed, trial date is always going to be remote. There's always going to be a year, because that's kind of within the year of when the case is filed, if it progresses anywhere close to reasonably. So a motion for summary judgment's going to be early, and trial is there's going to be time to prepare for the expert. So it's a defeat of the statute to just say, well, trial's a year and a half away, so we don't care about the deadline. We'd ask the court to grapple with this a little more and reverse the district court. Thank you.
The case of Wilson versus Shenandoah Medical Center is hereby submitted. We'll have a brief pause here while the next attorneys can get ready for their case. Vanachuk versus Lander.